Dr. IP, and this is Idea Defense 101. How's it going? Today we are talking about trademarks, and I've agreed to arbitrate a dispute between Voiceover Guy and his neighbor Vocal Above Man. You know what, I think we're going to need a change of scenery for this. That's better. Now, what seems to be the matter?
This guy is always copying me.
Let's keep it to the trademark dispute, if you please.
The defendant is using a trademark that is too close to mine.
Am not.
Oh, two.
Even if a defendant is not using the exact mark, they can still be liable for trademark infringement where their mark is likely to cause confusion, mistake, or deception among consumers about the source of goods or services. Not surprisingly, a very similar standard is used at the U.S. Patent and Trademark Office for determining whether to allow registration of a mark. One common example is when two marks are spelled differently but sound similar. For example, one mark could be Apple, the other could be Apple. Or one mark could be Samsung, while the other is Samsung.
That's something slimy like you would do.
I'll hang you upside down by your if you know what I mean.
Another common example is where the marks have a similar meaning. Take this real-life case where Gas City was deemed likely to be confused with Gas Town. But even when such similarities exist, a likelihood of confusion is not likely to be found unless the goods or services that the marks are used for are related. They don't have to be identical, just similar enough that a consumer would be likely to assume they come from the same source. So if one company is selling computers and the other is selling vacations, there's not likely to be a lot of confusion. But if one company is selling donuts and the other is selling bread, those could be found to be related.
Are we done with the lecture now?
Yeah, can we cut to our case now, Dr. IP?
Hey, that's Your Honor, Dr. Judge IP. Now, let's have a look at your marks.
My mark is People Eyes.
And what is it used in conjunction with?
It's a webcam that is embedded in your monitor, so when you look at the screen, it looks like you are looking at the camera.
Okay. And the defense, what is your mark and its associated goods?
It's called Peep Eyes. It's a camera you attach to your peephole.
Before I rule, I should mention that every case is highly factually sensitive, so always be sure to consult an attorney whenever a dispute arises.
Well said.
Stop sucking up to the judge.
Hey, don't trash about me.
Don't
Order in my court. All right. The marks are very similar sounding, I think you would both agree, and they're both in the field of cameras. To me, that is related enough that I think a consumer would be duped into thinking that all of the products come from the same source. So on that basis, I find for the plaintiff in this matter. Next case. Looks like this is going to take a little while. We'll see you next time.